men inclusive of women and men. In other words, it should be people and free institutions. Our laws, incidentally, especially as our laws are written from a criminal standpoint, seek to preserve that moral compass. And over the years, our jurisprudence in Dominica and the Caribbean by extension has emerged. In a free and democratic society, people do have the right to challenge certain laws, especially if they believe that the laws infringe on the guaranteed rights under the Constitution order. There were similar rulings in similar countries with similar laws, namely Antigua, St. Kitts and Nevis, Trinidad and Belize. And to say further that the law is organic, and especially over the years our jurisprudence has emerged. Laws have been challenged, rulings have been issued by the court, and of course the consequential precedents that have emerged over the years, which we have to follow. So tonight we're going to start with by enabling our wonderful young ladies here tonight, if they don't mind that I refer to them as young ladies, to introduce themselves. I'll start firstly with Miss Kathleen Nesty, and then we'll go down to Mrs. Sobers and the Director of Public Prosecution. First, just tell us about yourself and your current position.
Hello, good evening, everyone, to the listening and viewing public. My name is Kathleen Nesty, and currently I am the Acting Permanent Secretary in the Ministry of National Security. I'm also an attorney at law, and I have been an attorney at law for over 12 years.
Good.
Yeah, but before you say for over 12 years, where were you actually engaged initially, and give us an idea as to the background of what you're doing at the Aegis Chambers?
Okay, well, I've had my stint through the government service. I did work at the Attorney General's Chambers as well, dealing with all matters that relate to the state and defending the state. And thereafter, I moved to Registrar of Companies and Intellectual Property.
Okay. So you do have some experience in
I also worked at the Director of Public Prosecution's office as well.
Okay, thank you.
Good evening to the listening public as well as those viewing us online. My name is Vanica Sobers Joseph. I am currently temporarily the Solicitor General attached to the Chambers of the Attorney General. I was called to the bar in Dominica and Trinidad in 2008 and in Barbados in 2009. So I have roughly 15, 16 years experience as an attorney at law. I have worked in both the public and the private sector, representing the government in commercial contracts as well as in litigation, which is what I currently do in the Chambers of the Attorney General. And I always like to make a point of referencing that I am married and have 2 children, because I think it's important to know that there is balance in life.
I agree.
Pleasant good evening to the listening public. I am Shoma Dalrymple, Director of Public Prosecutions. My career as an attorney at law started at the Aegis Chambers, where I represented the state in civil matters, land matters. I did contracts. And then in 2012, I moved on to the Office of the Director of Public Prosecutions, where I was a state attorney and who prosecuted matters ranging from murders, sexual offenses, grievous bodily harm. I like to say that I'm a career public servant because I believe in giving back to the state, and I'm just basically enjoying law. At the Office of the Director of Public Prosecutions, our goals are to prosecute matters and to always ensure that justice prevails. We also serve as ministers of justice, that is, prosecutors are ministers of justice, which most times the public doesn't understand, that our role is not solely to obtain a conviction, but to ensure that both sides, both the victims and the accused, rights are maintained within the confines of the Constitution.
Okay, thank you very much for your very impressive introduction, each one of you. Let me just first start with Miss Nesty, and to actually give us a perspective. And I want to just add that the state, notwithstanding the previous rulings, in contrary to similar laws, that the state felt that that's a matter it should respond to, and consequently ensured that special counsel was retained to assist the personnel within the AG's chambers. And let me take this opportunity to commend the AG along with staff for doing that, and to just give us a perspective as to, from the government standpoint, what was done from the ministerial standpoint also.
Well, yes, Mr. Minister. Let me also commend the state and the Attorney General Chambers for also representing the interests of the state in this matter. I know there have been some pronouncements that the state did not represent, did not defend this matter. And I think it may be because people may have looked to the matter and looked for a defense. And it's a constitutional matter. So the course of action and the presentation of documents may be labeled differently to the average person. So the state would have submitted their affidavit in reply on behalf of the defendant, who is the state, and therefore thereafter presented their submissions, which would have been ventilated by the courts. So yes, this matter was well ventilated and represented by the state in its entirety. And I would say that I commend the state because, as it stands, Dominica took a stance to actually expound on the issues that was presented to the court in contradiction to other jurisdictions, in so much so that we did not get any cost afforded to us. So that in itself speaks highly of the defense that was, or the submissions that were placed on behalf of the state.
Now, insofar as it relates to the caliber of the special counsel that we retain, do you want to give the public an idea as to?
Well, Mr. Dorset, Dr. Dorset, yes, he was well acquainted and has a vast, he's from Antigua, and he is familiar with these type of matters, and he would have ventilated the issues in its entirety, and he's well versed and knowledgeable in this type of law and dealing with these matters. So we return someone of the highest expertise in which to represent the state's interests in this regard.
Okay, so to give us a better perspective of the legal issues and the challenges as to how the state responded, and the order the orders that were actually the order that was ultimately laid down. Let us listen to the acting Solicitor General to give us a broader perspective and to look at, to more or less disaggregate the matter in a structured manner to give the listening public an idea as to what actually transpired. And I said disaggregate because there were a number of challenges, and there were different results. And it seems to me that within the public domain, there seems to be a one-dimensional perspective that is being actually transmitted or deposited in the public domain. So maybe you want to just run through what actually transpired and to give us, in a sequential manner, on account of the.
Okay, thank you, Honorable Minister, and thanks to you for allowing the Chambers of the Attorney General to speak on these issues. It is not often that the Chambers is offered the opportunity to do so. And I would like to say that, notwithstanding the other public servants here, I often feel that the Chambers is a diamond among the gems in the national security. And we appreciate the responsibility it is to represent the state and to defend the Constitution when the matter arises as a constitutional matter. And that is exactly what this was. It was a constitutional matter. And as the judge in her own judgment said, if it is read, the judge said it is important to say at the outset the case is not about whether the action, choices, or lifestyle of persons are right or otherwise correct, but whether in the context of the Constitution, the law as is should continue to stand. And what I want to reiterate and restate is that the law of buggery has not been struck off the books. The law of buggery is still very much on the books. What has happened with this constitutional challenge is the sections are being interpreted to allow for consenting adults in the privacy of their homes not to be subject to criminal prosecution. And that has to be restated. Decriminalization is not legalization. That has to be stated. So the law of buggery still stands, and the DPP could speak to the criminal elements of buggery and what actually is the law as is, but it still stands. Now, as it relates to the substantive matter, the constitutional claim, if I am permitted to read, it says the claim was by a private citizen of Dominica, and the challenge was myriad. There were multiple challenges to the law. There was a declaration that the criminally prohibiting and penalizing consensual activities between persons 16 years and older was an infringement of their right to liberty, their right to freedom of expression, their right to freedom of assembly and association, the right to privacy in the home, the right to security of person, and the right to protection of discrimination.
Sorry, just take a pin. You're talking about same-sex adults.
In the context of this,
Okay,
yes.
fine, okay.
And the claimant asked for an order prohibiting the Commonwealth of Dominica Police Force from laying charges under Section 14 and 16 of the Sexual Offences Act. That order was not granted. I need to say that at the outset. That order was not granted. And the claimant also asked for certain other declarations.
Before you go further, when you say that orders, that specific order that would have prevented the police from laying charges pursuant to
Section 14 and 16.
That order was not actually agreed to.
No, because as I said earlier,
what I wanted to do is to take it a little further and break it down. Now, let us say, are there protected people that, of course, within the context of a minor, somebody below the age of 16, or even if an adult, without his consent, were to be, exposed to that kind of behavior, he can make a report and a charge of burglary can still be preferred also fast.
That is very correct. That is very correct. And in the approach that the chambers took, we wanted that to be brought out in the judgment.
Okay.
That as it relates to minors and persons who do not consent, the law still applies. The law as is still applies.
Right.
The effect of this judgment is essentially as it relates to persons who are adults, consenting, and in private. So if you're an adult and you do not consent and you wish to make a report, the law still facilitates that. If you're a minor or if you know of a minor that has been subjected to the offenses under the Act, the law still stands for that. So I would like to restate that, right? And certain acts of sexual intercourse cannot happen in the public domain. The law still stands as it relates to that.
While you're there, and if you want to give some more currency to a fundamental issue there in terms of solicited in the public, is that permitted?
Well, I would not want to speak beyond where my legal expertise ends, which is on the constitutional claim. So that might be a proper question for the Honorable DPP.
Mm-hmm. But go ahead, that's all right.
And I would afford her the opportunity to answer now so that we don't lose the moment.
In respect of soliciting in the public, this would fall under section 14 of the legislation, which is gross indecency.
Right.
Again,
Was it 14 or 16?
16 is burglary and 14.
Okay, yeah.
Section 16 deals with burglary, section 14 deals with gross indecency. Now, in respect of gross indecency, the declaration that was made by the court for how the section has to be now interpreted and read is that you can do your acts in private. Consenting adults can have acts done in private. However, these acts cannot be done in public. So, as Ms. Sobers was indicating earlier, it's not a matter of the section 14 being completely struck off the books. The law is still there. It's just that it has decriminalized certain aspects of how the act is done and who it applies to. Consenting adults in private will not be prosecuted. But in public, acts of gross indecency, individuals can be prosecuted for acts of gross indecency, and also acts of gross indecency against minors. They can be prosecuted for it. And I must add, Mr. Minister, that this has generally been how these matters have been dealt with, because we don't have any, insight into what is done in your home, in your bedroom.
Okay. Let us go back, because you're dwelling on a very important matter. If you don't have a victim, then
where does the matter go?
Precisely.
We need a victim to prosecute these matters.
Fine. But let us go back to we'll come back to that fundamental issue on a more when you speak in a more comprehensive manner on the whole issue of section 14 and 16. But let us go back to Mrs. Sobers as he further ventilate the issues there.
Okay, so for the purposes of the constitutional challenge, the legal approach that was taken is that we are aware in the Commonwealth of Dominica, we follow the common law system. The common law system means that you follow the law as it evolves with cases. The law is a living, breathing organism. The law is not stagnant. The law is organic. It changes over time. And in the common law system, we are guided by what we call the doctrine of precedent, which means an earlier case is regarded as an example of what should be followed in a subsequent case, and it should be considered, unless that subsequent case or the earlier case is so different in circumstances, in law, in facts than the previous case. So under the doctrine of precedent, there are cases that the courts are obligated to look at. The court must look at those cases. They must consider those cases. And in our current situation, we were coming into the defense of the state's position with the awareness that recently in Trinidad, in Belize, in Antigua, as well as in St. Kitts, judgments were handed down by the courts in similar sections, with similar sections, in similar circumstances, that did say that as it relates to consenting adults in private, looking at the law as against the Constitution, those particular sections were unconstitutional. So bearing that in mind, the state wanted to ensure that we did not attempt to go in fighting a battle, that we have precedent. And as officers of the court, and as the DPP said earlier, you have an awareness that you have to conduct yourself with the knowledge of what the precedent is. So it would have been disingenuous to go before the court and argue a case knowing the precedent existed and knowing that it was open to us to follow that precedent. And because in the Eastern Caribbean we are a jurisdiction of multiple courts over multiple jurisdictions, and the court in one jurisdiction is guided by learning similarly in other jurisdictions. So coming into this case, there was the Antiguan case, there was the St. Kitts case, there was also the Belizean case and the Jamaican case, the Trinidadian case. After the arguments, the Barbadian courts also ruled in similar vein, right? And the laws across the board, having been inherited from our colonial masters, for lack of a better term, are similar. And in taking that approach, knowing the precedent, it was incumbent upon the state to ensure that we ensured that the attack on the sections were limited to consenting adults in private. We wanted to make sure that the law continued to maintain the rights of protecting minors as well as protecting persons who do not consent.
So are you saying, notwithstanding the rulings, that the state put on a fight and is saying to the court or said to the court or the judge in that case, we have learned and we know of the ruling, but we want that matter to be considered within the ambit of our morals?
There was opportunity for that, the morality aspect of it, to be presented to the court, and in the sense of there were interested parties added to the case. There were interested parties in the sense of the Bishop of Roseau, the Anglican bishop as well, and also the Dominican Association of Evangelical Churches. Right? So the Bishop of Roseau would have represented the Catholics, the Anglican bishop would have represented the Anglican church position and the morality of the church position on that, as well as, I believe, the Methodists
Yes.
were there and making representations before the court to maintain their arguments of preserving the morality of society. As the state, we are guided by the law and the Constitution, and irrespective of what our own private and personal views are, as officers of the court, we are guided by the law and the Constitution.
Okay. So, in other words, therefore, let us just reiterate for emphasis for those who are just joining us, that it is still not permissible by law to engage in that kind of activity with a minor or somebody who may be an adult but who has not consented.
That
it
is
all
correct.
boils down to two people 16 and above who have consented. Basically, that's it.
That is correct.
Okay, fine.
In the privacy of their
The
home.
privacy of the home. We'll get to that just when we get to Miss
And I would like to add that, as the DPP indicated, in the past, and that was part of our defense, the police has never prosecuted persons, and if I am permitted to find it, the police never prosecuted individuals, right? We put that into our defense, and that was repeated in the judgment. It said that in the 20 years prior to this case, there were 69 reports of alleged burglary made to the Commonwealth of Dominica Police Force, none of which related to consensual activities between adults. And the police, as far as I'm aware and based on the evidence, do not go looking for consenting adults to drag them into the police station to criminalize their conduct. Police investigations are usually initiated based on complaints and criminal complaints, right? And of the 69 reports that were made, 10 were arrested and charged for the offense, and those arrests and charge was followed by complaints, persons coming in and complaining, this happened to me, I did not consent, I did not wish for it to happen, and so on.
Yeah, but it's important to understand that a minor cannot give consent,
No.
and somebody was referred to as an imbecile cannot give consent. So that those are inconsequential. So even if somebody who was below the age of 16 would say yes, and that person happened to be male or female, and that act is actually committed on that person, the offense of burglary would have been committed.
That is correct.
Right. Okay, great. Now, there are other issues that you may want to ventilate here tonight, and as it relates to sexual orientation. I'm not sure if you want to speak to that, because I know our Constitution does not reference sexual orientation, so I was kind of surprised that that topic even emerged. Do you want to give some light on that?
Well, I could give light in light of what the judgment in and of itself says. In the judgment, the arguments were being made that the reference to sex here included discrimination based on sexual orientation and those other things. And in the judgment, the court disagreed with that enlargement of what sex means in the context of Dominican Constitution. And that was based on robust arguments from the state pointing out to the court that no, even if in other jurisdictions the Constitution is drafted in such a way that it would permit that interpretation, in Dominica that is not the case, and to allow for that expansion is not within the confines of what the Constitution allows for. So the judge said, and I would like to quote from the judgment at paragraph 93, additionally, I note, as counsels for the defendant points out, that in some cases cited by counsel for the claimant, the constitutional provisions differ from Dominica's constitution. The differences permit, on the words of the text, a more generous interpretation of sexual orientation as a prohibited ground of discrimination. Such differences expressly prescribing sexual orientation as a prohibited ground, for example, South Africa. But this catch-all phrase cannot be applied and was not applied in Dominica.
Okay, great. Now, as we're here talking about the various challenges, do you want to reference the specific sections of the Constitution that were actually challenged and the consequential ruling that actually emerged out of the arguments?
Okay, so the claimant's counsel challenged the right to liberty under section 1A and 3, the right to freedom of expression under section 3.2, the right to, my apologies, under section 1B, the right to freedom of assembly and association under section 1B, and section 11.1, the right to privacy of the home under section 1C, including protection from entry of others on one's premises without consent, and the right to security of person, the right to protection from inhumane or degrading